Hello everyone. In this session, I will be presenting the module Nuclear Energy and Law, which has been prepared by Dr. M.P. Ram Mohan from the Terry University, New Delhi. By way of introduction, this module provides a broad understanding of the history, evolution, and institutional and legal frameworks that have evolved and that govern civilian nuclear energy program. The module covers both international and Indian legal instruments and institutions that relate to civilian nuclear energy. A distinction has been made in the beginning itself that the module covers the civilian aspect, which relates to energy production, etc., and not the military part of the program. What are the learning objectives of this module? After completing this module, the readers will be able to understand the complex scientific, historic, institutional, and legal framework in respect of the development and use of nuclear energy. In terms of the outline of this session, we will first go through a background, followed by some slides on the development of nuclear energy law, followed by institutional developments, a brief comment on the Nuclear Non-Proliferation Treaty, followed by some discussion on India and nuclear energy. This will be followed by a discussion on the international legal and regulatory framework, the nuclear liability regimes, and as well on nuclear safety and security. Finally, the session will be summarized for you. In terms of background, the modern development of nuclear science has its beginning as early as 1789 with the discovery of uranium by a German chemist, Martin Klaproth. Throughout the period from 1800 to 1900, efforts have been directed to find out more about the nature, composition, and use of uranium and its properties. In the year 1938, Otto Hahn and Fritz Strassmann, through their experiments, discovered the process of fission in uranium for the first time. Consequent to this, chain reaction became a possibility, which subsequently made the work in developing an atomic bomb a step closer. The Second World War from 1939 to 1945 hastened the development of military application of nuclear science. On 2nd December 1942, scientists led by Enrico Fermi achieved the first self-sustained nuclear chain reaction in Chicago. With the prospects of Germany acquiring the nuclear bomb seeming closer, Albert Einstein's letter to President Roosevelt informing how close the Germans were led to the formation of the Manhattan Project. The Manhattan Project was conceived in 1939 and led by the United States with participation from the United Kingdom and Canada, became the nerve center in the development of the atomic bomb during the period 1942 to 1945. In July 1945, the United States tested its first atomic bomb in New Mexico. Soon after, in August 1945, USA exploded two atomic bombs on Hiroshima and Nagasaki, showing the world the destructive power of nuclear energy. That is, human and environmental consequences from nuclear radiation exposure. It may be remembered that the action of bombing Japan took place only a few weeks after the heads of states signed the United Nations Charter on 26th of June 1945 in San Francisco. With the war ending and knowing well that the United States and its allies may no longer hold monopoly in nuclear science, efforts were directed to control the spread of nuclear weapons. At the same time, attention was also being directed for peaceful application of nuclear energy. The newly formed United Nations became the focal point in this effort. These efforts led to the development of nuclear energy law as we know it today. As Werner Boulanger stated, the purpose and function of nuclear law is to promote and to protect. To promote the development of nuclear science and technology, and to protect mankind against any hazards possibly connected with nuclear energy. Nuclear energy law, in effect, had to confront or to deal with multiple factors. These include proliferation, which refers to the diversion of civilian use to weapons program, protecting the industry and the public equally from massive compensation claims and provisions for the same, the establishment of an effective and credible regulator to ensure that the operator and all others follow the strictest regulations for a safe program, and to make sure that the program does not have any unintended consequences for the environment and the people, like waste management, public consultation, radiation risk, etc. We will now discuss the institutional developments relating to nuclear energy. Now, the United Nations shouldered much of the responsibility to answer the nuclear question, its uses and concerns, since this topic is best discussed formally at a multilateral institutional level involving all the permanent five members of the UN Security Council, which include China, France, Russia, the UK, and the United States, as well as other countries. In 1945, there were extensive consultations, in particular between the United States, the United Kingdom, Canada, and later the USSR, on the need in an effort to reach agreement on the conditions under which international cooperation might replace rivalry in the field of atomic power. Subsequently, on 15 November 1945, during a summit in Washington, D.C., the United States, the United Kingdom, and Canada issued the agreed declaration on atomic energy, stating that in order to attain the most effective means of eliminating entirely the use of atomic energy for destructive purposes and promoting its widest use for industrial and humanitarian purposes, a commission should be set up at the earliest practicable date under the United Nations to prepare recommendations for submission to that organization. On 27 December 1945, at a meeting of the Council of Foreign Ministers in Moscow, the United States and the United Kingdom proposed, and the USSR agreed, to create the United Nations Atomic Energy Commission, or the UNAEC. On 24 January 1946, the United Nations General Assembly passed the first resolution in its first session, creating the UNAEC with representatives from the United States, USSR, Canada, United Kingdom, and others, in an effort to consider problems arising from the discovery of atomic energy and related matters. Though well intended in its efforts to establish an international oversight of the use of atomic energy with the hope of avoiding unchecked proliferation of nuclear power post World War II, the working of the UNAEC has been contentious. The United States and the then USSR proposed different proposals, which led to their non acceptance of either of these proposals. After 3 years of deliberation and almost 200 meetings, the UNAEC failed to reach any major agreement. In September 1949, the USSR conducted its first nuclear weapons test, followed by the United Kingdom in 1952. The Soviet nuclear test effectively ended the UNAEC's role, and the UN General Assembly, by a resolution of January 1952, formally dissolved the UNAEC, creating in its place the UN Disarmament Commission under the Security Council with a general mandate on disarmament. While negotiations were going on at the international level, countries continued their research to establish the technical superiority over nuclear energy. An important effort towards the production of electricity from atomic energy became successful in the year 1951 when electricity was first generated from a nuclear reactor at the National Reactor Testing Station in the United States. Many countries initiated their programs during this year. Immediately after World War II, in a period before the incident of electricity generation in the US, in order to institutionalize the post-World War nuclear energy program, the United States government enacted the Atomic Energy Act of 1946, which emphasized the need to harness atomic energy for peaceful purposes. The Atomic Energy Act created the United States Atomic Energy Commission as a civilian-controlled authority. In parallel, throughout the 1940s, the USSR also directed its effort to the development of nuclear technology, including both for military and civilian purposes. In respect of the civilian power program, the 1940s saw giant strides at various centers in refining existing reactor designs and developing new ones. Obnitsk became one of the nerve centers of the Soviet nuclear energy program and became famous when on 27th June 1954 the first world's nuclear power station at Obnitsk with a capacity of 5 megawatt was connected to the Moscow grid. Once all the major powers of the day acquired atomic technology, international efforts were redirected to arrive at a common ground on the use of nuclear technology for peaceful applications. On 8th of December 1953, the Atoms for Peace speech by US President Eisenhower before the UN General Assembly called for the governments principally involved to make joint contributions from their stockpiles of normal uranium and fissionable materials to an International Atomic Energy Agency set up under the UN. Moving forward on peaceful application, in 1954, the United States provided a legal basis for Atoms for Peace by amending the Atomic Energy Act to permit peaceful international nuclear cooperation, leading to bilateral agreements with a number of states. The amended act drastically altered the policy, thereby facilitating the participation of private enterprises in the development of atomic energy. The UN General Assembly, in a plenary session in December 1954, unanimously adopted a resolution which provided for the establishment of the International Atomic Energy Agency, or the IAEA, and for the holding of an international technical conference of governments under the auspices of the United Nations. The success of the international conference took the slow pace of negotiations to establish an International Atomic Energy Agency to a level of urgency. Majority of the countries thought that the IAEA could be used to access nuclear technology in setting up nuclear power plants. The interest generated during the conference persuaded many nations to launch nuclear research and development programs and sharpen their interest in the proposed institution. Finally, the Statute of the International Atomic Energy Agency was approved in October 1956 and it came into force on July 1957. The main functions of the International Atomic Energy Agency are to take any action needed to promote research on, development of, and practical applications of nuclear energy for peaceful purposes, to provide materials, services, equipment, and facilities for such research and development, and for practical applications of atomic energy with due consideration for the needs of the underdeveloped areas of the world, to foster the exchange of scientific and technical information, to encourage the exchange of training of scientists and experts in the field of peaceful uses of atomic energy, to establish and apply safeguards to ensure that any nuclear assistance or supplies with which the IAEA was associated should not be used to further any military purposes, and apply such safeguards, if so requested, to any bilateral or multilateral arrangement, to establish or adopt nuclear safety standards, and to acquire or establish any facilities, plant, and equipment useful in carrying out its authorized functions. India is one of the architects of the Statute of the International Atomic Energy Agency and played an instrumental role in shaping the working of the organization. Particularly on the constitution of the governing board of the IAEA, Fisher explains that in the 12-nation group, the Indian delegation came up with a complex but ingenious formula that has stood the test of time. Moving on to the Nuclear Non-Proliferation Treaty of 1968. The objectives of this agreement, which was signed in 1968 by both major nuclear and non-nuclear countries, was to stem the spread of nuclear technology. It is the most widely adhered to multilateral disarmament agreement, but the non-parties include countries like India, Pakistan and Israel, and North Korea, which withdrew from the treaty in 2003. The treaty classifies nations into two categories: nuclear weapon states and non-nuclear weapon states. Nuclear weapon states are those countries that possess nuclear weapons but have committed to negotiate elimination of nuclear weapons. And the non nuclear weapon states are those countries that are barred from acquiring nuclear weapons but they are given nuclear technology for peaceful applications, for example, energy production. Today, although many of the provisions of the treaty remain unfulfilled, there can be no doubt about the importance of the treaty towards global nuclear disarmament and promotion of nuclear energy for peaceful purposes. Insofar as India and nuclear energy are concerned, although there are no major uranium reserves in India, India has one of the largest reserves of thorium in the world. Therefore, from the beginning, realizing that India does not have the major uranium reserves, India conceived a three-stage nuclear fuel cycle strategy. The reactor program that was conceived was with the installation of natural uranium reactors in the first phase, followed by fast breed reactors in the second phase, using plutonium from the first generation reactors with either uranium 238 or thorium in the blanket, followed eventually by reactors based on the self-sustaining thorium-uranium 233 cycle. Today, India has many nuclear reactors spread across the country producing electricity, which is operated by the Nuclear Power Corporation of India Limited or NPCIL. Now, nuclear energy forms an indispensable form of energy for India towards industrialization and to provide electricity access to large number of population. The advantages of nuclear energy are that a high output can be achieved on small fuel and limited land. For example, just two projects in Jaitapur and Kundankulam, it is possible to generate approximately 10,000 megawatts and 9,000 megawatt of power respectively. Nuclear power projects highlight the importance of public acceptance and the need to engage with and consult with communities that live close to nuclear projects. It is also important to allay the fears through a sustained education program which should be launched by the government. Further, it is also important to have a clear legal regime which is beneficial to all the parties. India's nuclear program started as early as in 1945 with the establishment of the Tata Institute of Fundamental Research in Bombay. The Atomic Energy Act was passed in Parliament soon after the country gained independence in 1948, and it set forth India's objective for the development and utilization of atomic energy solely for peaceful purposes. In 1954, the government established a Department of Atomic Energy charged with the sole responsibility of all nuclear activities in the country. The Indian Atomic Energy Act of 1948 is a principal legislation that deals with all aspects of atomic energy production and its associated activities in India. The Atomic Energy Act of 1962 gives the central government monopoly over production, development, use, and disposal of atomic energy. Under the provisions of the law, the central government undertakes the above activities either by itself or through any authority or corporation established by it or through a government company. In terms of the legal and regulatory framework concerning nuclear energy, we will first focus on the liability and compensation laws. Now, having experienced the consequences of the horrific bombings in Japan and knowing well that the traditional principles of state responsibility and liability may not suffice in respect of a nuclear accident, the Organization for Economic Cooperation and Development, or the OECD, established the Convention on Third Party Liability in the field of nuclear energy, also known as the Paris Convention, in 1960. This is a nuclear liability regime for most of Western Europe. Supplementing the Paris Convention, the 1963 Convention, supplementary to the Paris Convention of 29 July 1960, which is also known as the Brussels Supplementary Convention, was established to provide for enhanced compensation. The International Atomic Energy Agency sponsored an international regime in 1963, the Vienna Convention on Civil Liability for Nuclear Damage, also known as the Vienna Convention, largely on the principles laid down in the Paris Convention. The principles, which remain the bedrock of state responsibility and liability, are as follows. First is the no fault or absolute liability principle. The second one is the principle on legal channeling, which basically means that liability will be channeled exclusively to the operator of the nuclear installation. The third principle, which relates to exclusive jurisdiction, states that only courts of the state in which the nuclear accident occurs have jurisdiction. The fourth principle relates to limited liability and provides for a limitation of the amount of liability and the time for claiming damages. This is also the principle on limitation in time. Finally, the sixth principle states that the operator must secure insurance or financial guarantee to the extent of his liability amount. With both these conventions being independent of each other, it was open to states to adopt either of these conventions. This raised the issue of coordination and harmonization between the two conventions. After the Chernobyl nuclear accident in 1986, to rectify this problem, the two conventions were linked by the joint protocol relating to the application of the Vienna Convention and the Paris Convention, which came into force in 1992. Along with this, there was a complete revision of the Paris Convention and the Brussels Supplementary Convention. The 2004 protocol to amend the Paris Convention on third-party liability in the field of nuclear energy amended both the Paris Convention and the Brussels Convention. The Vienna Convention has also undergone significant changes. In 1997, over 80 states adopted a protocol to amend the 1963 Vienna Convention on civil liability for nuclear damage, which came into force in 2003. In addition to the Paris Convention and the Vienna Convention, at the insistence of the United States, the International Atomic Energy Agency sponsored another international nuclear liability regime, which is known as the Convention on Supplementary Compensation, or the Compensation Convention, in 1997. This convention is structured as an umbrella legislation. It provides additional amounts to be offered through contributions by the state parties on the basis of their installed nuclear capacity. However, the convention is still not in force. In India, the Civil Liability for Nuclear Damage Act of 2010 came into force on 11th November 2011. The law retains most of the established international principles, but it is argued that it deviates on two major contentious points. One is the right of recourse against suppliers in respect of who are covered and the extent of their liability, and second is the right of citizens under tort law to approach courts for claiming more compensation. These are yet to be settled. The Civil Liability for Nuclear Damage Rules 2011 have also been framed in respect of a few provisions, and they were notified on the same day along with the Act. In terms of the nuclear liability regimes, countries have established national regulatory institutions. Many institutions, like the United States Nuclear Regulatory Commission, started with promotional and regulatory duties together, but later changed to perform specific regulatory roles. Today, some of the efforts of the NRC are focused on reactor safety oversight, reactor license renewal of existing plants, material safety oversight, materials licensing for a variety of purposes, and waste management of both high-level waste and low-level waste. In addition, the NRC is preparing to evaluate new applications for nuclear plants. Insofar as the Indian context is concerned, the Atomic Energy Act of 1962 envisages regulatory and safety requirements. The Atomic Energy Regulatory Board, or the AERB, is the regulatory body that lays down safety standards and rules and regulations in regard to the regulatory and safety requirements envisaged under the Atomic Energy Act of 1962. The AERB was constituted on 15th of November 1983 by the President of India by exercising the powers confirmed by the Atomic Energy Act to carry out certain regulatory and safety functions under the Act. The regulatory authority of the AERB is derived from the rules and notifications which are promulgated under the Atomic Energy Act and the Environment Protection Act of 1986. The AERB is currently structured under the Atomic Energy Commission, reporting to the chairman of the AEC. In order to provide independent legal status, the government has tabled a legislation called the Nuclear Safety Regulatory Authority Bill of 2010, also known as the NSRA Bill. When the bill becomes a law, there will be structural changes in the current AERB, and the bill says that the AERB may be subsumed under the NSRA bill. Insofar as the international framework is concerned, the IAEA, on its part, taking forward the obligation under the statute, has been at the forefront of framing, collaborating, and disseminating standards of safety through its program, fundamental safety principles, safety requirements, and safety guides. These instruments reflect international consensus on what constitutes a high level of safety for the protection of people and the environment from harmful effects of ionizing radiation. As the primary publication in the IAEA Safety Standards series, the Fundamental Safety Principles establish the fundamental safety objectives and principles of protection and safety. They convey the basis and the rationale for the safety standards for persons at senior levels in government and regulatory bodies. The second publication, known as Safety Requirements, establishes the requirements that must be met to ensure the protection of people and the environment both now and in the future. These requirements are governed by the objectives and principles of the safety fundamentals. The format and style of the requirements facilitates their use by member states for the establishment in a harmonized manner of their national regulatory framework. The third publication, known as Safety Guides, provides recommendations and guidance on how to comply with the safety requirements, indicating an international consensus on the recommended measures. The safety guides present international good practices, and increasingly they reflect best practices to help users striving to achieve high levels of safety. Now, the standards, these three publications, are applicable throughout the entire lifetime of facilities and activities, both existing and new, which are utilized for peaceful purposes. It is also applicable to protective actions to reduce existing radiation risks. Now, three nuclear accidents: the 3 Mile Island nuclear accident in the United States in 1979, the Chernobyl incident in the former Soviet Union in 1986, and the nuclear fallout subsequent to the earthquake and tsunami in Japan in 2011 have exposed the nature of nuclear accidents and their possible impacts on humans and the environment. In addition, in the post 9/11 attacks in the United States, there has been heightened concern regarding the possibility of nuclear materials getting into the hands of terrorists. Governments the world over have taken a series of measures to counter this possibility. As a result, there are a host of international and national legal and institutional instruments in respect of nuclear energy production, its use, and safe disposal of waste. The list covers terrorism, securing safety of nuclear facilities, transboundary issues, transportation of nuclear materials, personnel working in nuclear facilities, their safety and security, export and import of nuclear materials, management and safe disposal of nuclear waste, decommissioning, etc. In order to share valuable regulatory experience on safety, the Convention on Nuclear Safety was adopted in Vienna on 17th of June 1994 under the auspices of the International Atomic Energy Agency. The objective of this convention is to legally commit participating states operating land-based nuclear power plants to maintain a high level of safety by setting international benchmarks to which states would subscribe. The obligations of the parties to the convention are based to a large extent on the principles contained in the IAEA Safety Fundamentals document called Fundamental Safety Principles. These obligations cover, for instance, siting, design, construction, operation, availability of adequate financial and human resources, assessment and verification of safety, quality assurance, and emergency preparedness. Now, in summary, nuclear energy development has had a checkered history, both as a technological sensation and in terms of its risks. In terms of a technological sensation, nuclear energy has the potential for energy production and has great medical and agriculture benefits to offer. In terms of risks, we have been exposed to the human and environmental devastation resulting from a nuclear accident. Nuclear law covers legal instruments and institutions governing production and use of nuclear energy, but there is a need to allay fears through establishment of robust laws and institutions for regulation and protection of nuclear energy. There is also a need for more acceptance of the legal instruments relating to nuclear energy. Thank you very much.